Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about telecommunications. Cases that should have gone to the Supreme Court of Canada, but didn't. Under Canadian law, responsibility for issues involving telecommunications is federal jurisdiction, meaning that the provinces can't legislate or regulate or do anything about it without permission from the feds. A telecommunications company that dealt with maintenance, installation, and operation of cell phone towers was charged with a number of provincial offenses in Quebec as a result of their business and the way that they were carrying on business. In defending themselves against the provincial charges that they were facing, the telecommunications company argued that they were not subject to Quebec law because they were under federal jurisdiction and the Quebec government didn't have the right to legislate about them or to impose consequences on them in their activities as telecommunications repair technicians. This is where the case raised an important issue that the Supreme Court of Canada should have been involved in. The Quebec court ultimately found that they were subject to the Quebec law. The reason being is that although they were engaged in telecommunications work, they were not a federal telecommunications company. Rather, they were a Quebec company working on telecommunications projects in contract work in that area. Essentially, a Quebec company contracting services to the federal government or for a federal purpose, as opposed to a company performing only federal government services and performing only federal acts. This is a nuanced distinction, but it's an important one, especially for lots of individuals who are working as contractors who might be working between provinces, in multiple provinces, or working on federal projects while being contractors in the province that they live in or that their offices are in, and wondering what law they're subject to. The laws as they apply to contractors who work on federal projects as opposed to federal companies that work on federal projects should be interpreted in a consistent way. And if there's going to be a delineation, then that delineation needs to be made very clear in our legal system. This was an opportunity for the Supreme Court of Canada to deal with a very rare issue of the division of powers and how the province can potentially steal power from the federal government by legislating in a way that affects contractors who are performing federal work. This is a significant issue that could lead to further bleed through in the division of powers and ultimately end up eliminating the intention of Parliament when they enacted the Constitution to create the division of powers in the way that they did. This case should have gone to the Supreme Court of Canada for these issues to be addressed. And unfortunately, it's going to take another case involving another contractor performing federal work in a provincial legislative system before this issue gets addressed. And that's very confusing and a very unique set of facts that's going to happen for a long period of time before somebody hopefully gets charged with an offense. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.